Thank you, Mr. Chairman. It's interesting that the name of the hearing is executive power and constitutional limitations, or as Mr. Fein says, what power does the executive have? And virtually every Republican member in the opening statements said if we're having a hearing discussing constitutional limitations on power, therefore it must be by nature an impeachment inquiry. I would hope that I'd like to ask the witnesses what things kind of short of impeachment we may be pursuing, because if we want to enforce laws against misleading Congress and getting us into a war, or enforcing the laws against torture or illegal wiretaps or corruption in the Department of Justice, do we have to be talking about impeachment? We heard in terms of impeachment, Mr. Rapkin suggests that the suggestion that we've gotten into war by misleading information is ideology, demented, explosive charge. Some of these we know as a matter of documented fact that what was said turned out not to be true. And I think the comments from Professor Presser have been commented on by Mr. Anderson and Mr. Fein, and the suggestion that covering up a sexual affair is impeachable because it had some personal motivation, whereas misleading us into war, corruption in the Department of Justice, torture, and those kinds of things were irrelevant. I think we've discussed that. So I guess my question is that is there a limitation on the ability of the executive to provide false information to Congress that we rely on that gets us into a war? And if we don't pursue impeachment, what else could we do? How do we enforce the constitutional limitations on the use of torture? We've had this administration essentially just redefine torture to permit what everybody else in the world believes is torture. And we've had allegations by Republican-appointed officials who have accused this administration of firing U.S. attorneys because they refuse to indict Democrats in time to affect an upcoming election, and suggesting that others may have kept their jobs because they, in fact, pursued frivolous charges. Another said under oath that or at least she did not deny taking partisan political considerations into consideration in hiring Department of Justice personnel in violation of the law. In our investigation of these allegations, we've been faced with witnesses who refused to respond to subpoenas, refused to testify without immunity. Others refused to cooperate, claiming unprecedented privileges. So I guess my question is how we can enforce the limitations on power, on executive power, in light of the situation we find ourselves in without using the impeachment inquiry process.
When President Nixon was under investigation by the special prosecutor, and there was a concurrent Senate Watergate hearing, then a House impeachment hearing, there was very deep examination. I was in the Department of Justice at the time, and then acting Attorney General was Bob Bork, a later Supreme Court nominee, as to whether or not you could criminally prosecute a president in lieu of impeachment while he remained in office. And it had been highlighted in part because you may recall that Vice President Agnew was actually prosecuted for tax evasion, and then he resigned afterwards. He probably would have been impeached if he didn't resign. But the conclusion was that you cannot criminally prosecute a president who's incumbent because there's just one figure who can make executive decisions. You can't have an acephalous branch, so to speak, unlike the possibility of prosecuting a member of Congress or a Supreme Court justice where the institution would continue to function. But the corollary of that conclusion is that short of impeachment, there isn't anything you can do about a president, and that in some sense underscores the political nature of the decision. It's one that can't be shirked because there isn't any other way to get at an abuse of power. I'd just like to make one observation about the idea of misleading Congress as an impeachable offense. And this is a quotation from James Iredell. Now, he was appointed by George Washington to be on the first Supreme Court of the United States. He was there, if you will, at the creation, to borrow from Dean Acheson. And he was speaking to the North Carolina Ratification Convention. And this is what he said: "The President must certainly be punishable for giving false information to the Senate. He is to regulate all intercourse with foreign powers, and it is his duty to impart to the Senate every material intelligence he receives, whether he believes it or not. If it should appear that he has not given them full information, but has concealed important intelligence which he ought to have communicated, and by that means induced them to enter into measures injurious to their country, and which they would not have consented to had the true state of things been disclosed to them, in this case," he asks, "isn't that clearly an impeachable offense?" So the Founding Fathers understood exactly the situation that has been alleged in this case. Not necessarily that President Bush lied. It's clear he didn't give the full slate of information to the Congress that was available regarding weapons of mass destruction, collusion with, between Saddam and al-Qaeda or otherwise. And this is, as the Supreme Court has said, a virtual definitive interpretation of an impeachable offense because it was made by someone who was there at the time, participated in the convention and ratification. It's not something that's concocted after the fact.
Thank you. Mr. Barr? I'm sorry.
Oh,
And Ms. Holtzman.
Thank you. If I could, with the indulgence of the Chair, just respond briefly. There are, of course, a number of things that Congress can do legislatively. We've touched on a number of them here today with regard to state secrets, signing statements, executive privilege, and so forth. But I think in answer to the gentleman's question, at an absolute minimum, Congress cannot make matters worse, which it did in passing recently the amendments to the Foreign Intelligence Surveillance Act, which not only vastly expanded the power of the executive branch to surveil American citizens in their own country without cause or without court order, but gave both retroactive and prospective immunity to companies that demonstrably, even from what little we know thus far, given the parameters and extent of secrecy practiced by this administration, clearly violated the law as well. And Congress, not this committee certainly, but a majority of members of both houses basically have set the constitutional clock back considerably by caving in to the administration on that just one particular instance where the executive branch has not abided by the law and not abided by the very clear intent and wishes of the Congress.